to do what. And I can deal with that in a few paragraphs.
Well, in a few sentences probably.
A few sentences. I will follow the court's direction. In bullet point then, the lady, the ANC is a universitas. Put differently, it is a body corporate. It differs from an unincorporated association in this crucial respect. The ANC has a life of its own. It has a separate existence from its members. It can hold property itself, and it can sue and be sued in its own name. So that's what we have before us. A universitas which is of the type of a body corporate, and we've given the references to the authorities, that's clear. Secondly, how is this body corporate run? And the Constitution is very clear that it is run by the National Conference, which is the supreme body. Between the national conferences, the NEC, the National Executive Committee, is the supreme body. The structure at provincial level mirrors that at the national level. The provincial conference, subject to various directions, is the supreme authority in the province, and the Provincial Executive Committee, subject to the directions of the National Executive Committee, is the supreme authority. And the organization is run on voting lines. Now, this court has found that there were no proven voting irregularities. So the point in relation to Rule 17.2.1 is simply relating to the authority to call the conference. The ANC Constitution works off democracy. Democracy is aided by having elections. It aids democracy to have more elections than less. That is a crucial point of interpretation. And we say that against that background, another court may reasonably find that one must give meaning to the words at least. They can't simply be in a situation where they are to be read as not there. One cannot simply draw a pencil or a red ballpoint pen through it and disregard them. The meaning must be there. And it's a meaning that is replicated at national level because the national equivalent of the rule refers to at least once every 5 years. So against that background, we say that at a national level, the National Conference can call as many, the National Executive Committee can call as many conferences as it likes. Now, it's true that there's nothing in the Constitution that says expressly who shall call the National Conference. But it's obvious from the overweening powers of the National Executive Committee that they have the power to call the conference. And we say that mirrored at a local level, it is the PEC who has the power to call the conference, subject to the directions of the NEC. And we say that's exactly what happened here. Was the PEC called for the conference and the NEC approved the provincial conference. Now against that background, we say, if we return to the wording, quote, the provincial conference shall be held at least once every 4 years, means that it can be held more often than that, and there is no sanction of invalidity. And we submit that an appeal court could reasonably adopt that interpretation in a context-driven interpretation. So, although Rule 17.2.1 says it can be held more often if requested by at least 1/3 of the branches, that relates to an additional power that is given to the branches to request, and it's no more than a request. Now, it was a point of debate at the main hearing as regards whether this was a request that could be refused, because the wording is the provincial conference shall be held at least once every 4 years and more often if requested by at least 1/3 of the branches. So the inquiry was whether shall relates to both be held at least once every 4 years and to the second part of the sentence if requested by at least 1/3 of the branches. We submit that that's debatable. It's a matter of interpretation upon which an appeal court could disagree with this court. But more fundamentally, we say that that shall relates to the request for the conference. It doesn't say, the shall doesn't say you shall not call a conference if it is not requested by at least 1/3 of the branches. So the shall, we say, might be interpreted by the appeal court to relate only to the request by the 1/3 of the branches and what should happen in relation to that. It doesn't detract from the power of the NEC or the PEC, subject to the directions of the NEC, to initiate a conference at all. And that's a point that wasn't explored during the argument. How far does a shall go, and does it relate to or is equivalent to a prohibition against calling the conference? And the ordinary language used does not seem to apply beyond simply what should happen in relation to at least once every 4 years. And if you give that the normal interpretation, it means it can be held more than at least once. In other words, once is not the same as at least once. Once is a sub-minimum. And where the power of the branches comes in is if they are not happy with the number of times that the provincial conference has been called during that 4-year period, that they have the power to request an additional provincial conference. So we say that that's a fundamental point, and if the appeal court were to agree with that, the appeal court would not have to go into the complicated additional leg of the argument, which occupied a lot of the time of this court, and that was the timing argument. So I turn now to the second leg of our argument in relation to Rule 17.2.1, and that is the timing and the language. And we say that the interpretation adopted by this Honourable Court was that the conference must be called once every 5 years. And we say that amounts to calling the conference once every 5th calendar year, which is completely different, we say, from the language used in 17.2.1. And we have struggled with how one would recast that rule to accord with the interpretation adopted by this Honourable Court. And we have set out in our papers that it would require a lot of explanation to get to that, and completely different wording. One could go the long way around by saying, well, it's got to be called once every 4 calendar years. In other words, one strikes out the wording at least once, and that calendar year must start at the 1st of January in that particular year, and then you cannot hold a conference during the 4-year calendar period starting on the 1st of January. Now, that's a lot of additional wording. It's completely different wording from that which appears in the rule. And we submit that there's a reasonable prospect that an appeal court would adopt what we submit as a clearer line to say, well, you must give every word meaning, and at least means at least a sub-minimum, and there's no prohibition against the NEC or the PEC calling for more. We've analysed in our heads what is meant by calendar year. A calendar year, according to our understanding of the authorities, in the current interpretation begins from any particular day in the year. It doesn't begin at the 1st of January in every year. Now, it may be that in a particular case it could be held that it does, but that would require particularly clear wording. And included in the extract from authorities at page 52, we have included paragraph 296 of the latest edition of Law So, which is on the electronic publications, which deals with the concept of a calendar month. Now, we know that a month is not an issue here, but it has a certain resonance at the level that calendar is used quite often, both in relation to month and in relation to year, so they must have a similar meaning. According to the learned authors, quote, calendar month has been accepted as meaning a month computed by reference to any 2 corresponding dates in successively named months of the year. The term calendar in the statutory definition thus imposes calculation by reference to corresponding dates on the calendar. Now, the context of that reference was in relation to the Interpretation Act, which doesn't apply here. We've got the civilian method of calculation. But turning to the next page, at page 53, we have the learned authors of Lawsa expressing themselves in relation to a period expressed in years, and they say the year The term year can refer either to one of the successively numbered annual cycles of 365 days that recurringly commence on 1 January and end on 31 December, or to a similar period of days starting on any date in a particular year. This is at the Indexed Authorities, page 53. And then, quote, in the computation of time, the second meaning is current, although a particular provision may indicate that the first meaning, the cyclical year beginning on 1 January, is intended. So, if the word calendar is to be interpolated into the wording of clause 17.1, that in itself is not a clear solution to the problem of interpretation, because it brings in its wake, when do you commence the calculation for the calendar year?
Yes, Mr. Harper, if you read further on page 53, it goes on to say that the term calendar year is
Correct. That's the author's point, is that one has to look at the context for what is intended. But as we understand the authors, they say that the default position is that it refers from a particular moment in time, starting at any time during a year, unless there is a clear indication in the language to the contrary. And we say that not only is there no clear indication in the language to the contrary, but the word calendar doesn't even appear in Rule 17.2.1. It also doesn't appear in the rule dealing with the calling of the National Conference. It would seem that the inspiration for the calendar year interpretation was to be found in a passage in Ramakatsa. But we've looked at that passage in Ramakatsa, and with respect, the point was not an issue there. It was simply a statement as regards when a particular conference would be held during a particular year. And we say that that passage in Ramakatsa is not definitive either way. The issue was not before the court, and it was a chance remark. What emerged in argument for the first time raised by this honourable court was perhaps this was similar to World Cup sporting events, which the theory was by this honourable court that World Cup events, one starts calculating at the 1st of January, and then if you've held the event in that particular year, then there can't be another one for a particular period of calendar years. Now, that no doubt is an interesting theory, but there's nothing in the papers about that. And no party has ever adduced the constitution of any of these sporting codes. One simply does not know from the papers what they say and to what extent the new interpretation can withstand scrutiny, even by way of comparison to what is contained in the other constitutions. And we say that, with respect, an appeal court might adopt the approach that this is not something upon which judicial notice may be taken, but it instead involves a factual inquiry in respect of which there is simply no evidence on the papers.
Those references are simply in passing, Mr. Harper.
Yes, I
it's
understand.
On the interpretation. It just appeared to me as the author sensible, as the Constitutional Court also held in Rita Ramakatsa matter, that if you have it in 2008, then the next one's in 2012. But if we're wrong on that, I understand your submission that you say, well, another court might conclude differently. But yes, certainly I was not trying to prop up the argument in this case with reference to the World Cup, although it was just a similar type of situation.
Yes, no, we fully appreciate that.
Yes.
Where you have ambiguity, the authorities, on our understanding, are quite clear that one can look at how the authorities themselves have interpreted a particular provision as a guide to what the parties actually meant. And in particular, the Unica judgment at paragraph 35, this is at page 37 of our extract of authorities handed up a short while ago, says that one must look at the factual matrix. Quote, all the facts proven that show what their intention was in respect of entering into a contract, the contemporaneous documents, their conduct in negotiating and communicating with each other, and importantly, the steps taken to implement the contract. And that is also consistent with what appears in the Novartis case, where the court referred to sorry, I've given the wrong reference. The first reference was in fact to the Novartis case. That's at page
37.
37, yes. So that's what the Supreme Court of Appeal said in Novartis. Turning to the Unica case, that's at page 40 of the extract. There's a very clear exposition in the concluding paragraph which says, quote, all that needs to be added is that it can be accepted that the way in which the parties to a contract carried out their meaning, their agreement, may be considered as part of the contextual setting to ascertain the meaning of a disputed term. And then there's some authorities quoted, and then the concluding sentence reads, quote, this is because the parties' subsequent conduct may be probative of their common intention at the time they made the contract. So we say the authorities are clear that one can look at what happened in the past. And at page 18 of our heads of argument, paragraph 65, we have set out in the form of a table when the previous conferences were held. I'm not going to go through that line by line. I'm assuming that the court has read that. It appeared both in our grounds of application for leave to appeal and in our heads. But the court will note immediately that not a single one of those conferences has ever been held according to the once every fifth calendar year interpretation that was in fact adopted by the court. And we say that's a strong indication that this was simply not intended. They were all held in lesser periods. And the curiosity is that if one adopts the 5-year interpretation, we submit one has to go back right to the beginning. And if one goes right back to the beginning, the 7th Provincial Conference was in fact, sorry, the 8th Provincial Conference was in fact held on one of those 5-year anniversaries. But we submit that's purely coincidental. We have also set out another table which deals with the argument that was raised regarding the period of office, because the court sought assistance in reference to how long officials would be in office for. And we made the submission that that is really a 4-year period that is stipulated on the assumption that the official is still in office, that he's still been elected, as it were. So that's something that can change if there is an election. And that change can occur on our interpretation and the respondent's interpretation. And also on the interpretation adopted by the court, you're never going to have an exact concurrence of that 4-year period if the conferences can be held at any time in the first calendar year and then at any time in the 5th calendar year. You're always going to have a disparity in that regard. And we say that one of the main problems with the interpretation adopted by the court is that if you have your conference occurring, as this one did, for example, in May of the first calendar year, if the 4-year period is to also commence at the 1st of January, then you've got the official who is employed before he's actually been appointed. And we say that results in a problem for the interpretation adopted by this court to put matters at their lowest, because it seems on the face of it not to be sensible to suppose that an official can have his term of office running before he's actually appointed. And we say that those two must go together. The theory postulated by the court is that the two must go together. If they must go together, then that official's term must begin on the 1st of January as well, and it simply can't be correct with the utmost respect. We have then set out at page 26 of our heads of argument a table on the relative chronology where we summarize the timing of it. And we say that the interpretation...
I think you set out in detail, in fact, all the points which you are now repeating. Perhaps we don't need to be taken through it point by point, but maybe just a summary of it, because it is all in your heads in writing before us.
Yes, Mary, I appreciate the direction, and I'll truncate my address accordingly. The point is that all the interpretations have problems, but we submit that the respondents...
At the end of the day, it is going to depend on an interpretation if leave to appeal is granted.
Yes.
Eventually, that's what it is. So
Yes.
we don't need to, at this point, be dealing with every aspect that will be
Yes,
dealt
certainly.
with by an appeal court if leave is granted.
Yes. I appreciate that, my lady. So then, my lady, I will shorten my address accordingly. Similarly, in relation to PAJA and time barring, we've set out our submissions in detail. The main point we want to emphasize is that we think an appeal court could lay heavier emphasis on the principle of proportional representation, and that it's actually the political parties that, by virtue of their proportional representation system, appoint the people who are officials in government. It's not the ordinary voter who does so, and that casts a huge public importance role upon political parties, and it moves it, we submit, into the sphere of administrative action. And we maintain those submissions. So if the court pleases, those are our submissions in founding on the application for leave to appeal. We submit that the application for leave to appeal should be granted, and that in relation to costs should be costs in the appeal.
Just a moment, Mr. Taylor. I think we have one more respondent.
Oh,
yes, 38 respondent
sorry.
first. Is there a problem?
Thank you, my lady.
Dealt with many of the points already, so if there's anything further you would like to add,
That is so, just one or 2 points.
Thank you.
All that the third point will say, my lady, is this: is that we fully agree with the respondent, first to the 37 respondents' argument in relation to the interpretation of clause 17.2.1. And we submit that, my lady, there can be no serious opposition to the fact that the interpretation of Rule 17.2.1 is crucial to the 38 respondent. It's important. The interpretation that has been accepted by this court has never been conducted by the 38 respondent before. The mere fact that it's a new interpretation, it makes it very compelling, my lady, that with respect that another court actually has to decide on this aspect, because clearly the interpretation that the court will have to will give, my lady, at the end of the day, the 38 respondent will have to apply the interpretation granted by this court. So surely, in that case, my lady, it's crucial. It's compelling that another court must really hear this matter and see whether, in fact, a higher court will agree with this court, my lady. On those bases, we submit that it is highly compelling that a higher court, with respect, hear this matter in order to deal with this aspect of the interpretation of 17.2.1 once and for all. Those are submissions on this aspect, my lady, in relation to the interpretation.
I'm not sure that you're right that it's never been interpreted that way before. If you look at Annexure SA1,
yes,
the Mpumalanga one was expressly recorded in a resolution or statement of the African National Congress to be holding an early conference as requested by the branches. But be that as it may, you say it's an arguable issue.
Yes.
Yeah,
Yes.
okay.
I'll say so, ma'am. Those are my submissions,
Thank
my
you
lady.
very much.
Thank you.
Mr. Chenko?
Deal with the interpretation issue and then with the PAJA time bar. Extraordinary thing about our learned friend's interpretation argument is that it ignores the language of the clause. And we submit with respect that it's the language, however important context might be, the language remains the starting point. And the language is unambiguous. It makes it clear that a provincial conference shall be held at least once every 4 years and more often if requested by at least 1/3 of all the branches in the province. Now, our learned friends lay emphasis on the fact that the first part of the sentence specifies a minimum, and that is true. But they ignore the second part of the sentence. The second part of the sentence is not an open-ended mandate to have more conferences. The second part of the sentence makes it quite clear that more conferences may only be held, quote, if requested by at least 1/3 of all the branches. So that the two parts read together make it quite clear that there has to be one conference at least every 4 years. And you may have more conferences, but only if requested by at least 1/3 of the branches. So and it is even now not clear which part of the clause our learned friends contend allowed a conference in November 2015. It's common cause that there was no request from the branches. And I'll get to their interpretation debate, a long interpretation debate. But on no interpretation does the first part of the clause permit a conference in November 2015. That was 3 years after the previous conference. So that really there is absolutely nothing to be said for their interpretation, because they don't bring themselves within the first part of the clause, once every 4 years, on any interpretation, and they don't contend that they satisfy the second half of the clause. They have to persuade you that over and above those two options of a conference once every 4 years and a conference at the request of the branches, there is a third option, an open mandate in the PEC to call provincial conferences. That is what they have to persuade you. But they don't make a serious effort to do so, not at all. They have a long debate about calculation, but the calculation leads us nowhere. So that if you start with the language, it permits only of two possibilities, and they don't bring themselves within either of the two. And we submit with respect that there is no arguable case that brings them either within one of those two, or that the Constitution somehow allows for a third possibility. The language is incapable of yielding that interpretation. So frankly, the interpretation debate need not go any further than the language, because the language is unambiguous, and on no basis do the respondents bring themselves within it. We submit that the interpretation is absolutely clear. There is only two possibilities, and on no basis do they bring themselves within either of those two. That is the language. But now let's take context, because my learned friend says context is everything. It is true that our judges sometimes say context is everything. They don't literally mean that one can ignore the language and look only at context. But the context is also against our learned friends. What do they do with context? What they do in their heads of argument, page 8, paragraph 23, they say, look at the powers of the National Executive Committee to call national conferences. They have a free hand, they say, to call national conferences. And therefore, they say, the PEC should also be understood to have such a free hand. We submit that context here points the other way, because what is significant is the difference in language that the Constitution uses when it deals with the calling of national conferences on the one hand and provincial conferences on the other. And that comparison, the comparison that our learned friends make, that comparison tells us that the Constitution intended one regime to govern national conferences and a different regime to govern provincial conferences. Let me just take you to the two provisions to which they point. The first is Rule 10.5, which says, and that's on page 65, it says, the National Conference shall be convened at least once every 5 years. So that's the equivalent of the first half of the rule that we're concerned with. And it's significant that it doesn't have our second half. The other rule they point to is Rule 29.1, which is at page 87. And it says, a special conference of the ANC may be convened by the NEC at any time or at the request of a majority of the provinces for the stated purpose of the stated purpose or purposes. And it is interesting that if you read those two rules together, that it provides for the same two possibilities as our rule does, but then adds a third. It provides for a conference once every 5 years. That's the equivalent of our first part. It provides for a conference to be called at the request of a majority of the provinces. That's their equivalent of our second part. But then they have a third part, the one that says may be convened by the NEC at any time. So what the drafter did when it regulated national conferences is specifically to confer a power on the NEC to call a national conference at any time. So what does one make of context? What one does make of it is to look at the rules that govern the calling of provincial conferences, and you see they provide only for two possibilities. Then you look at the rules that provide for the calling of national conferences, and you see that they have exactly those two comparables, those two possibilities, but they add a third, or at any other time. The clear inference is that as far as national is concerned, they may be called by the NEC at any time. As far as provincial is concerned, they may only be called once every 4 years or at the request of the branches. So that is context. Then lastly, purpose. What is the purpose of limiting the calling of provincial conferences only on those two possibilities, once every 4 years or at the request of the branches? Well, once every 4 years is obvious. That's because the term of office of the PEC is 4 years, and therefore you have to have a conference once every 4 years. And what the second part does is to say, the decision maker as to whether we have more conferences than the minimum should be the branches. It's a bottom-up democracy and not a top-down democracy. Whether a good or a bad idea, that is the obvious purpose of legislating that more conferences than the minimum may only be held if there's a request from the bottom up. So we submit that on no basis is there an open-ended mandate to call provincial conferences other than under those two possibilities, once every 4 years or at the request of the branches. Now we can leave out the at the request of the branches because that didn't happen in this case. So it leaves us with the possibility of once every 4 years. Now our learned friends devote half of their heads of argument to a debate as to what that means. And let me make this submission. I know that there's been a debate before, but I submit with respect that the basic interpretation of once every 4 years is absolutely clear. If you have it in 1 year, then you may not have a conference again earlier than 4 years after the initial conference. And my learned friends speak of the court's interpretation as if it yields an anomaly, because it says it interprets the rule to mean the conference takes place in every 5th year after the initial conference. Well, that is because 1 plus 4 is 5. If you have a conference in year 1 and you have to have a conference 4 years later, then the next conference will be in year 5. There's nothing odd about an outcome that says if a conference has to be held once every 4 years, then if you have a conference in year 1, the next conference has to be in year 5. But let me say this. I accept that there is room for debate as to precisely how that 4 years should be measured. Because one can measure it with varying degrees of specificity. The measure that the court adopted, which we submit with the greatest of respect, seems a sensible and a workable interpretation, is to say you measure it by year. In other words, if you have a conference in year 1, then the next conference must be in year 5, 9, 13, and so on. And therefore, if you had a conference in 2012, as in this case, the next conference has to take place in 2016. No interpretation gets you to November 2015. Now, that we submit is a perfectly sensible interpretation. Are there other ways of measuring the 4 years? Yes, there are. You may fine-tune your caliper by measuring the 4 years not by year but by month. And then you would say if the conference took place in May 2012, then the next conference must be in May 2016. You can tune your measurement even finer than that and do it by day and not by month. If the previous conference was on the 11th of May 2012, the next conference must be on the 11th of May 2016. But that fine-tuning of the measurement is a nice debate, but utterly irrelevant to this case. Because on no possible basis, if you have a conference, we know that the previous conference was in May 2012. On no possible basis is 4 years after May 2012 get you to November 2015. That is 3 years after the 2012 conference, not 4 years. So that the debate is truly a red herring, because regardless of the outcome of the debate, on no possible interpretation was it competent to have a conference in November 2015. So we submit with the greatest of respect that where there is room for debate, i.e. about the precise measurement of the 4 years, that debate is irrelevant. On the fundamental interpretation that there are only those two possibilities, and there's no viable argument that brings them within either one of those possibilities. And we submit with respect that there is absolutely no prospect of persuading a court of appeal that there is a third possibility, incompatible with the language, incompatible with the context, incompatible with the purpose.
Mr. Tringo, is anything to be made of the words in Rule 17.2.1 of at least once? You know, if it said shall be held every 4 years,
No.
But for better or for worse,
It does say
it says at least once every 4 years.
It does say at least once.
We concluded that it means once every 4 years.
Yeah. Well, it says once every 4 years, and then the second part tells you that you can have more conferences, but only if there's a condition for having more conferences. The condition is a request from the provinces. And the language...
Sorry, from the branches.
From the branches. The language can't be clearer. Must be held at least once every 4 years, and more often, not more, and more often if you wish, more often if requested by the branches. So there's a condition for holding more conferences than the minimum.
No, there's not even a punctuation separation or anything.
No, No. So we submit with respect that not only is the interpretation obvious, but there is no reason to delay the finality of this case. And let me also say with the greatest of respect that this is a full bench judgment, judgment that has the status that an appeal judgment often would have, so that there is also less reason to be insecure about the outcome because it is a considered judgment by a full bench. Could I turn to the PAJA time bar point? We submit with respect that what the argument overlooks is that there are really 4 potential causes of action. And PAJA only governs one of them. And you can't superimpose the requirements of PAJA on the other causes of action. And let me just explain why I say so. The 4 possible causes of action, and that is really common cause, both sides, heads of argument and the judgment, and the Ramakatsa judgment makes this clear. The first cause of action is in contract. And that is because the constitution of a voluntary association is a contract between all its members, and if the constitution is violated, a member has standing to enforce it in contract. It is a good, solid, common law contractual cause of action. It's got nothing to do with public law or administrative law. It is a private law cause of action. And then there are 3 possible public law causes of action. In Ramakatsa, it recognizes a cause of action for a violation of Section 19 of the Constitution. That was the other cause of action upheld in Ramakatsa. That is a public law cause of action, governed by the rules of public law, and it ends up, if it succeeds, in Section 172 of the Constitution, which confers on the court a wide remedial discretion, equitable discretion. That's the second cause of action. Then there's a third cause of action for violation of Section 33 of the Constitution, the right to fair administrative action, which has been fleshed out in PAJA. So the third cause of action would be an administrative justice cause of action, subject to PAJA. The last cause of action, the fourth cause of action, would be a rule of law cause of action. And that's in fact the rules of public law that would govern the exercise of public power, which C of the Constitution. It also ends up in Section 172 of the Constitution. Now, if I may call these last 2 causes of action, the administrative justice cause of action and the rule of law cause of action, if I may call them just for shorthand, the administrative law causes of action, because they are very similar. One set of rules governs administrative action, another set of rules governs the exercise of power which does not constitute administrative action. But what the 2 of them have in common is that they are concerned with the judicial review of the exercise of public power. And they have all the rules of administrative law govern that exercise of public power. There are public law rules that govern the exercise of public power. One other feature they have in common is that those public law rules, the administrative law rules, are subject to the Odekral rule. That's the rule that says that an administrative decision or the decision taken in the exercise of public power stands until set aside. The other feature that both of them have in common is that they end up in Section 172 of the Constitution. They give the court a wide remedial discretion.
then one other feature they have in common, and that's the important one, is that they are both subject to a time bar. Because as the court said in Odekral, that remedial discretion of the court is exercised to strike a balance between legality on the one hand and certainty on the other in the public interest. But I must emphasize that these features, the Odekral rule, the remedial discretion, the time bar, whether under PAJA or a common law, they are features of these two public law causes of action. And they apply only to the public law causes of action. They are not applicable to contractual causes of action. And in this case, we submit with respect that although the applicant the contract was the contract that constituted the constitution of the ANC. The contract was breached in that clause, or Rule 17.2.1 was breached. That is a contractual cause of action. And whether or not it is also capable of being characterized as the unlawful exercise of public power is neither here nor there. It is in the first place a contractual cause of action. And may I, on that score, just refer to 3 paragraphs in Ramakatsa's case. So we have some cases that we can hand up. If I may refer to Ramakatsa's case, firstly paragraph 16. Where the Constitutional Court said of a similar case, I do not think that the Constitution could have contemplated political parties could act unlawfully. On a broad purposive construction, I would hold that the right to participate in the activities of a political party confers on every political party the duty to act lawfully. Paragraph 79. Where the majority judgment says the following, if I may leave out the first sentence and pick it up in line 3. At common law, a voluntary association like the ANC is taken to have been created by agreement, as it is not a body established by statute. The ANC's constitution, together with the audit guidelines and any other rules collectively, constitute the terms of the agreement entered into by its members. Thus, the relationship between the party and its members is contractual. It is taken to be a unique contract. And then in paragraph 80, as in the case of an ordinary contract, if the constitution and the rules of a political party like the ANC are breached to the prejudice of its members, they are entitled to approach a court of law for relief. And they cited Saunders, which said the following: there is no doubt that the rules and the regulations of a body like the Stock Exchange, just like the rules and the regulations of an ordinary club or the articles of association of a company, constitute a contract between its members, and that is the reason why any particular member, if the contract is broken to his disadvantage, has the right to come to court for the appropriate remedy. So whatever other rights the applicants might have had, they had a contractual claim. This court upheld the contractual claim. I don't need to take the court to the paragraphs in which it did so, but if I may just give you the numbers of the paragraphs. They are paragraphs 37, 61, and 110. This court made it clear that the applicants had established a contractual cause of action, and we submit with respect that that conclusion was inevitable. And given that that is so, of law, it is an ordinary, conventional contractual cause of action, and it is not subject to any time bar. Private law has other rules, and you know the rules of election and waiver and estoppel and so on. Those things are the regulating mechanisms that may cap one's freedom to bring a cause of action. But none of them are in play here. So that we would submit with respect that the suggestion that the claim was subject to a PAJA time bar overlooks the fact that the claim is in the first place a contractual claim which is not subject to any time bar at all. If we're wrong, then there is the debate as to whether it is PAJA or the common law that applies, in other words, whether it's administrative action or the exercise of public power. We submit that by no stretch of the imagination can the calling of a conference by a political party constitute administrative action. It does not affect the rights of outsiders. It does not have any direct external legal effect on others. So we submit with respect that even if we're wrong in our primary submission, that this court was correct in holding that it was not PAJA but the common law time bar that operates, and that the application was brought within a reasonable time, given that the party delayed its promised response to the complaints when they were first made. So for these reasons we submit, my lady, my lords, that there is really no prospect at all that another court will come to a different conclusion. Our learned friends say that there is another public importance consideration, even if they don't show prospects of success. We submit with respect that if there is a public importance consideration at play, then it is one that dictates that this matter should be brought to finality rapidly rather than slowly. The public interest is better served by a prompt conclusion of the legal process rather than one that is drawn out. All of these matters are going to become irrelevant over time once the following conference is held. If there is a public importance in this matter, then it is that finality be reached as quickly as possible. Nothing can be said to the contrary. So we submit with respect that there is indeed a further consideration beyond the prospects of success why leave to appeal should be refused. We ask for the costs of the application, including the cost of due counsel. Thank you, my lady.
Mr. Harper.
Thank you, lady, please. Our learned friends submit that the wording is clear, and in the first leg of their argument you don't even need to go into context as we understand them. The difficulty we have with that submission is that the wording is only clear if you read in the words that they want to be read in. And on my notes of what has to be read in, you have to go to Rule 17.2.1 and you have to read in the words may only be held if requested by 1/3 of the branches, or another formulation, only if. So it's not clear on the actual wording used. No doubt they want to read it in a certain way, and if the wording had been that, then it would have been clear. But it's not. Besides which, they remain with the problem of the words at least once. It does not say once at all. So they have to either add in may only be held or only if, and they have to delete the words at least once. So on their own showing of what has to be there, the wording is not clear. Besides which, the authorities are crystal clear that these days it is a unitary process. One doesn't start off and examine just the wording and see whether it's clear, and then against that finding disregard the context. The authorities that we've put up, starting with Indumeni and followed in Bothma Batha, emphasized it is a unitary process. It's a wrong principle of interpretation with respect to say one can focus only on the words. That was perhaps the law, in our submission, never the law, but perhaps arguably the law before Ndumeni. But it's simply not the law at present. Secondly, if the wording is so clear, as contended by our learned friends today, why did they not adopt the court's interpretation as their case? They argued for a completely different interpretation. So it certainly wasn't clear to them at the outset of the matter, or even in the argument before this court, that this wording means the equivalent of every 5th calendar year, because they never argued it. So if it wasn't clear to them at the outset, why should it be clear the way they see it now to the appeal court afterwards? Even the court, this honourable court, held that this was a difficult matter of interpretation, and we quote from paragraph 162 of the judgment, where the following appears: specifically in relation to the interpretation of Rule 17.2.1 of the ANC Constitution, it involved a matter important to both sides and which was a novel issue open for debate. Now, if it was clear, with respect, this court would not have written that. It cannot both be open for debate and crystal clear. Fourthly, our learned friends submit that the court, our quo, was a full bench judgment, and that is a consideration that counts against granting leave to appeal. My lady and my lords, we take issue with the use of language. There is a case that says that there is a distinction to be drawn between a full bench and a full court. This wasn't a full bench sitting as appeal, it was a full court comprising 3 judges. It was nonetheless a court a quo. Now, if one is talking about a full bench appeal and an appeal from that, that is a different set of circumstances totally. One requires special leave to go to the Supreme Court of Appeal. And the reason for that, we ventured to suggest, is that a full bench sitting as an appeal court has certain advantages. The issues have all been debated before the court a quo, and there's a judgment, and then there are heads of argument based on that. This interpretation would have surfaced somewhere in that process already and be debated, and an appeal court would have certain advantages, which, even if it comprised 3 judges sitting, which it usually does, is different in its composition and what it has before it from a full court sitting as a court of first instance. So we respectfully submit that whilst obviously the status of this court sitting as a 3-judge full court must be respected, it's certainly not equivalent to a full bench judgment which requires any higher bar for an application for leave to appeal. Our learned friends, in relation to the PAJA argument, lay heavy emphasis on Ramakatsa, but they, with respect, do not take into account the fact that there has been the subsequent Supreme Court of Appeal decision in Gajima, which may require a reconsideration or at least a clarification of what is stated in relation to Ramakatsa. And secondly, they do not take into account that PAJA itself, as emerged in the debate before this honourable court, in fact specifically includes an agreement within its ambit.
In Gajima,
Sorry, no, it's the Supreme Court of Appeal.
it went to the Constitutional Court, didn't it?
Constitutional
Sorry?
Court, and I think on the 17th of November this year, the court gave its decision.
And it upheld the appeal at least in part.
Yes.
I was unaware of that judgment.
Judgment of Victorious, AJ, and Badinia.
Yes. Well,
It upheld the appeal from the Supreme Court of Appeal in part.
on that point about the
Well, I can't. Certainly, what stands out in my mind it was that if an entity of state applies for a review of its own decision, then it's a legality challenge rather than a PAJA challenge.
Yes.
But exactly how it impacts, I'll have to read again.
Well, my Lords, I'm indebted for pointing that out. It's the 17th of November. It's now the 30th of November. So neither side have referred to it, but be that as it may.
This is it's Jafta J.
Yes. But, my Lord, just in relation to PAJA, our learned friends seek to compartmentalise it as strictly a contractual issue, which we submit is not the correct approach as well. Even our learned friends, the applicants, relied upon the Constitution to inform the content of the contract. And even Ramakatsa says quite clearly this raises a constitutional issue. So, my Lords and my Lady, we submit that this is still an open question. The fact that our learned friends devoted some considerable time to the debate and the intricacy of the debate reveals that it is also fertile territory for another court reasonably to come to a different conclusion. In relation to another compelling reason, as appears from paragraph 162 of the judgment of this court, as I have read out a short while ago, this involves a matter important to both sides. And it is clearly a matter of considerable public importance. The ANC is the majority party in the country, and my learned friend Mr. Kozwayo has pointed to the significance of this from the National Executive Committee's point of view, that this interpretation should be dealt with. It is correct, finally, in dealing with the finality point, that it is desirable to have finality in litigation, but that in itself cannot serve as a ground for discounting another compelling reason, or that there are reasonable prospects of success. And again, we point to the 8-month delay by the applicants in the first instance in approaching the court. They did not follow the speedy Ramakatsa route. Those are our submissions.
Yes, just that, my lady, we fully agree with the 37, with this 37 respondent submissions, and the leave to appeal, my lady, should be granted. Those are the submissions, my lady.
We'll take the short adjournment at this point.
They're not with us on the bench, but I mean...
Yeah, but I think
The first point I see if we go first.
yeah, my first point would do very well.
yethu siphinde sisebenzise imali yethu. Ona? Sure.
Sure, wait. Later.
We submit with respect that this application for leave to execute is exceptional for 3 reasons. If I may firstly start with the language of Section 18 of the Superior Courts Act, under which the application is brought. It says in subsection 1, subject to subsections 2 and 3, and unless the court, under exceptional circumstances, orders otherwise, the operation and execution of a decision which is the subject of an application for leave to appeal or of an appeal is suspended pending the decision. Well, I emphasize the word the operation and execution is suspended. And then the qualification to it is subsection 3 that says a court may only order otherwise as contemplated in subsection 1 or 2 if the party who applied to the court to order otherwise in addition proves on a balance of probabilities that he or she will suffer irreparable harm if the court does not so order, and that the other party will not suffer irreparable harm if the court so orders. So, for the moment, the part that I emphasize is the question whether the quote operation and execution of the order should be suspended or not. And that is odd language to use when one deals with a mere declaratory order. And that is why a mere declaratory order is out of the ordinary. I'm not suggesting that the section doesn't apply. I accept that it does. But the hallmark of a declaratory order is that it merely declares the law. In other words, it merely declares what the legal position already is. So that whether the court order stands or not, whether it is suspended or not, whether it's an operation and execution or not, the underlying legal position is a given and remains the same. So it is not as if the suspension of the order will give the respondents leave to treat the conference and its resolutions as valid, because they remain as a matter of objective fact. They are either valid or not. And if this court was correct in its finding that they were invalid, the suspension of its order its declaratory order doesn't affect the status quo. So that's the first unusual feature, that one is really just dealing with a declaratory order. Can I contrast it with an order reviewing and setting aside administrative action? There, the Odekral rule operates. The decision is deemed to be valid except to the extent that a court sets it aside. So that if you suspend an order of invalidity, the administrative action continues to be regarded as valid and enforced. There, the suspension order has real objective impact on the legal relationship between the parties. In our case, the order is merely declaratory and therefore has no objective impact on the underlying legal relationship between the parties. The second feature of this case, which is exceptional and we submit highly important, is that the solution lies in the respondent's hands. They have always been at liberty from the very first moment to accept that their conference and election was invalid and immediately to call another conference. We are now far beyond the 4-year deadline. They are obliged, if this court's judgment is correct, if they accept that it's correct, then they have not only license but an obligation to call another conference, to have another election, and to regularize their position. So this toing and froing to save an election of November 2015, which this court has held to have been unlawful and invalid, is incongruous. Why not adopt the obvious solution, whether they agree with the outcome or not, of just accepting it, calling another conference, and regularizing their position in a democratic way? That would have been a political solution to a problem rather than a legal solution. And in fact, that was the first response of the NEC after this court judgment came out. First response was to say, yes, we accept it. We're going to put in place an interim structure and rerun the election. That is the obvious and sensible way to go. And that is what the video would have shown you, but I'm not insisting that we show the video because it is not disputed that that was the NEC's first response. We submit the sensible response. And one can only speculate as to why these respondents don't opt for the obvious solution. Why do they cling to a 2015 election which the court has held to have been unlawful? Why not adopt the obvious solution of having a conference and electing a new PEC and put this controversy behind them? So that's the second unusual feature, is that the solution is in the hands of the respondents. The third feature is this. If this court were to suspend the operation of its order, that suspension will be final as a matter of reality. As a matter of reality, it will mean that they will continue to act as the PEC pending the final determination of the case. We have said in the papers, and they have not disputed, that the final determination of the case is likely to end up in the Constitutional Court in 2019. Now, by then, the term of office that started in November 2015 will be all but expired. The applicant's victory in this case will turn into a Pyrrhic, empty and vacuous victory. This case is not about the long term. This case is about the leadership of the party in the province for a period of 4 years. And the only question is, should they be entitled, should the court, by suspending the order, allow them to limp on with an unlawful leadership put in place in November 2015, when they have it within their hands to regularize the position, to choose a new credible leadership, and to move on? We submit with respect that there is absolutely nothing to be said for the insistence of the respondents, for reasons of their own, to cling to a discredited election and to play for time rather than simply to accept this court's judgment. Those are the exceptional features of this case. Firstly, that it's a mere declaratory order. Secondly, that the solution is in their hands. And thirdly, that the suspension order will be a final order because the nature of this dispute is a temporary one. May I then turn to the question of irreparable harm? Because what the section does is to say that the question of our and their irreparable harm must be assessed on a balance of probabilities. And may I say in that score that when one does that assessment, the court may and must have regard to the prospects of success. Now, our heads of argument contend otherwise, but I submit with respect that that submission in our heads of argument is mistaken, and it's based on a mistaken reading of two judgments of the Supreme Court of Appeal. That's the University of the Free State judgment and the Intlhameza judgment. If I may ask the court to go to the judgment of the University of the Free State. Paragraph 14 and 15. Where the court dealt with this issue as follows. A question that arises in the context of an application under Section 18 is whether the prospects of success in the pending appeal should play a role in this analysis. In Incubeta, Sutherland J. was of the view that the prospects of success in the appeal played no role at all. In Liviero, Wilge joint venture, Factual J. and Moshidi J. concurring was of the same view. However, in Justice Alliance...
Sorry, Mr. Chamberlain. Sorry. Wait, what paragraph are you reading from?
That's paragraph 14. Paragraph 14.
Of the Free State judgment.
Yes, University. Oh, I have a nasty suspicion that the wrong Free State. There are two Free State judgments.
Yes.
The one was on leave to appeal, and the second was on the merits. And what should have been included in your bundle is the leave to appeal judgment. And that was a judgment handed down on the 17th of November 2016.
This is the 28th of March. Right, so it's the first one.
I apologize for that oversight. The neutral reference is 2016 ZASCA 165 17 November 2016.
I think it's referred by Mr. Harper in his heads at page 64 as well.
Oh, I'm relieved to hear that.
Maybe the assistance on page 98 of the extract appears the paragraph that my learned friend is referring to. That's the bundle of authorities I handed up this morning.
I'm indebted to my learned friend. In paragraph 15, the court first recites the views of Sutherland J, Satchwell J, and Moshidi J to the effect that the prospects are irrelevant. He contrasts that with the views of Binns Ward J, who held that the prospects of success in the appeal remain a relevant factor. And then continues as follows in paragraph 15. I am in agreement with the approach of Binns Ward J. In fact, Justice Alliance serves as a prime example why the prospects of success in the appeal are relevant in deciding whether or not to grant the exceptional relief. Binns Ward J concluded that the prospects of success on appeal were so poor that they ought to have precluded a finding of a sufficient degree of exceptionality to justify an order in terms of Section 18. And that then was reiterated in the Intlhameza case in paragraph 44. Where the court said the following. In UFS, this court, after considering that Incubata had held that the prospects of success in the pending appeal played no part in deciding whether to grant the application, preferred the contrary approach of the court in Minister of Social Development and Justice Alliance. However, in UFS, in deciding the matter before it, this court recorded that the review record was not before it and thus had no regard to the prospects of success. We are in the same position in the present appeal. So that explains why the court did not, in fact, in those cases, have regard to the prospects of success, but that was merely because the appeal record was not before them. But both courts held that the prospects of success do remain a relevant consideration that ought to be taken into account. Now, we submit with respect that even if this court should conclude that there is a prospect of success on appeal and should therefore, well, this court or some other court should conclude that there is a prospect of success on appeal and therefore that leave to appeal should be granted, the probabilities are overwhelming that the appeal will fail. Merely to hold that there is a prospect of success doesn't mean that there is a probability of success. We submit that there is an overwhelming probability that the appeal will fail. And therefore, irreparable harm must be assessed, having regard to the likelihood that an appeal will be unsuccessful. If one then considers the probability of harm to the applicants, well, that much is obvious. An appeal will, a suspension order will rob them of their victory. It will at least do so until the appeal has been finalized, and I have submitted that it will for that reason rob them of their victory altogether, because there will be very little left of their victory once the appeal has been determined in 2018 or 2019. So that the irreparable harm to the applicants is manifest. They are entitled as members of the ANC in the province of KZN. They are entitled contractually and otherwise to lawfully elected leadership. And this court has held that the PEC does not constitute lawfully elected leadership. They have been unlawfully put in that office, so that the applicants suffer ongoing irreparable harm for as long as they remain in office. And the harm is not merely theoretical. We know that the country and the province is going through an era in which important political decisions will be taken. And the applicants are entitled under the Constitution to require those decisions to be taken by a leadership lawfully elected. And for as long as they are deprived of that right, their victory in this case is defeated. So that the victory will be defeated, we submit, if not altogether, then in very substantial part, if a suspension is granted. The only way to afford the victors the benefit of their victory is to implement immediately. Anything else would turn it into a Pyrrhic victory, and the justice system will have failed them, because the losers will have had their way by stringing out the process. As far as potential harm to the respondents is concerned, we submit with respect that there is no realistic prospect of irreparable harm, and I emphasize irreparable harm. Firstly, the court's order is a mere declarator, as I've said. It merely declares the law. To suspend it will not release them to act unlawfully. So the invasion of the court's order is, with respect, very limited, because it merely declared a legal position that already exists. Secondly, as I've suggested, the solution lies in their hands. I know that there is a theoretical difference between insisting to continue to live under the unlawful election of November 2015, but the practical and pragmatic solution lies in their hands. Why not just accept the court's order and run a new election and regularize the position? Why? They would be prejudiced only if they insist irrationally to cling to the outcome of the November 2015 election. And then, as far as probabilities are concerned, the overwhelming probability is that this court's order will be upheld. So, and if it is upheld, there will by definition have been no prejudice, because the final outcome will simply be the one that's been implemented in the meantime. So we submit with the greatest of respect that on the probabilities, the applicants will suffer irreparable harm if justice is delayed. The respondents will not suffer irreparable harm if the order is immediately implemented. And to the extent that they might be inconvenienced by it, the solution lie in their hands, the obvious solution, the solution that they initially opted for, and the solution which they inexplicably disavow today. So we ask for an order for the implementation of the judgment pending any appeal, whether by leave of this court or any other court. And we would ask for the costs of 2 counsel as well. Thank you, Milady.
Ringo, sorry, can I just ask you a few things? If the application for leave to appeal is refused, obviously I know about Mhlemeza and the order granted by the court quo there, but it seems to have been justified on the basis of the facts of that case, that the learned judge formed the opinion that regardless of what he would rule, there would be further appeals. Do you have any submissions on that point as to whether you're persisting with the application? Should the application for leave to appeal be refused?
Let me divide my submissions into, firstly, law and secondly, practicalities. As far as the law is concerned, your Lordship is quite correct. And Mhlemeza held in paragraphs 27 to 32 that it was competent to launch such an application and for the court to make an order on it in the circumstances where, and I quote from paragraph 32, the High Court reasonably apprehended on the evidence before it that further appeals were in the offing. So that is enough, is a reasonable apprehension of further appeals. And we submit that in this case, the respondents have demonstrated a determination not to let go, and they've made it quite clear. When we invited them to go directly to the Constitutional Court, they've made it quite clear that they insist on going the long route via the SCA. So as a matter of law, we submit that there is a reasonable apprehension of a further appeal and therefore that an order is competent. That as far as the law is concerned. Let me speak practicality. We wouldn't want to burden this court with a judgment if it is going to be irrelevant on a moot issue. So I invite my learned friend to tell us whether they propose to take the matter further if this court were to refuse leave to appeal. Because if he were to say today, no, we will abide the outcome and we won't seek to petition the SCA, then I would accept that that's the end of the road and we won't persist in our application. But if our learned friend does not give that commitment, then we submit that there remains a reasonable apprehension of a further appeal and that an order would then be appropriate. I would suggest that even then we would invite our learned friends, if at any time they change their minds and they give up the pursuit of a further appeal, that they inform the court, and the moment they do so, a judgment on this issue will become unnecessary. But until they do so, I'm afraid a reasonable apprehension exists that they will pursue this until they stop, and for that reason we ask for an order.
And then another further issue, sorry, is one which I would value your assistance. Having read the papers, and maybe I missed it, I am still not quite clear exactly what powers this PEC exercises. The complaints have been that they are all, the respondents, first to 37th, are not remunerated for what they're doing, that there are at best certain appeals that might be made from branches to the PEC. that was in the context where they said, but in any event, it's not the final say. It goes to Minister Pandor, who's apparently been allocated to deal with these for KZN, except in the case of Mr. Supazuma, if he excuses me for using his first name, I've forgotten which respondent, who's a paid person, who will lose his salary or stipend. But apart from that, being removed from their what we have found to be invalidly elected positions, what is the prejudice? What is the harm?
With respect, there is none. One has a right to participate and stand for election. You don't have a right to be elected. And we submit with respect that if they opt for the obvious solution, and that is to call a conference, rerun the election, the right to participate and to stand for election will be fully honored. What they will lose is their election in a discredited and unlawful election in November 2015. But one doesn't have a right to election. One has a right to stand for election and to participate. So in a real sense, there won't be any prejudice at all. How can a politician be heard to say, I don't want to expose myself to the democratic judgment of the people because I want to cling to my election and not run the risk that I might be turfed out in another election? That's not a value that any respectable politician can subscribe to.
Thank you.
We submit that the starting point of the inquiry is what was stated in Ramakatsa, and the distinction between the facts in this case and in Ramakatsa. In relation to the second of those points, in Ramakatsa it was found that there were voting irregularities. In this case, it has been found that there were no voting irregularities that have been proved. So as far as the proven facts are concerned, leaving aside the calling of the election, these officials who are in the PEC were validly elected as far as can be proved or not proved otherwise. They were voted for, they are part of a democratic structure, and they are, but for the court's finding regarding the calling of the conference itself, validly elected. There's nothing wrong with the voting for these officials. They reflect the democratic will of the conference. Whether the conference was validly called or not is another inquiry entirely. Now, there was a difference of not much time on the interpretation, if it works out. This conference was held in 2015. On the interpretation of the court, it could have been held in 2016 and what should have been held in 2016. The applicants have made no case that these same people would not have been elected at a conference which is called on the court's interpretation, allowing for a slightly longer period. So that's a vital distinguishing factor between our case and the Ramakatsa case, in that our case, their voting was valid. These are democratically elected officials. And even in a stronger case, an R40RI case in Ramakatsa, the Constitutional Court pulled back, stopped short of ordering that the existing officials must step down and that another set must be appointed in their place. And the relevant passages are from paragraphs 121 to 125 in Ramakatsa. The appellants there submitted that the court should hold that the provincial conference and the decisions made are unlawful and void, that it would be just and equitable for the Constitutional Court to order the ANC to install an interim structure in terms of section 12(2)(d) of the Constitution. Now that section is in fact 12.2.4 of the present Constitution, and that says that the National Executive Committee shall ensure that the provincial structures function democratically and effectively. Now that has actually been done in the sense of voting. Leave aside the question of whether the conference was validly called. And then this section goes on to say the NEC may suspend or dissolve a PEC where necessary. A suspension of the PEC shall not exceed a period of 3 months. Elections for a PEC which has been dissolved shall be called within 9 months from dissolution. And then it goes on to say the NEC may appoint an interim structure during the period of suspension or the dissolution of the PEC to fulfill the functions of the PEC. The point to make is that it's within the powers of the NEC to appoint the self-same officials who've been validly voted into office as the interim structure. They have it within their powers and their province to do so in the terms in which the declaratory order was granted by this court, at least until another election. And that changes completely the complexion of the applicant's argument.
And if an order was granted in terms of Section 8 or pursuant to Section 18, then likewise they could take such a decision.
Exactly. So one questions how any of the factors in Section 18 could be fulfilled against this background, where we've got validly voted for officials in place, and they could be appointed as the interim structure. So the entire rationale and argument for interim execution simply collapses.
Well, that presupposes they are appointed
Well,
as an interim measure.
It may be, yes. It doesn't presuppose it. It says there is the power to do so. The applicants would have to show that that is not an eventuality that could take place. And they can't do that. They have no power to dictate to the NEC what they should do. This court expressly left it up to the NEC. And they don't say that that would be an inequitable or undemocratic result. It must be a democratic result because the people were validly voted for. They were unable to prove anything to the contrary. So that we say is a crucial distinction which should be drawn between what happened here and in Ramakatsa. But even so, in Ramakatsa, as we've indicated, they deferred to this self-same authority of the NEC, and they quoted. They carry on to say in paragraph 123 that the ANC drew their attention to Rule 11.3 of the National Conference to review, ratify, alter or rescind any decision taken by any of the constituent bodies, units or officials of the ANC. And we've made the point in the papers that at the forthcoming National Conference there is an item on the agenda already dealing with this particular Rule 17.2, and it may well be that at that stage the National Conference ratifies any lack of authority that there may be in relation to the calling of the conference in the first place. Now,
Yeah, I must confess, Mr. Harper, I don't quite follow that argument. If the interpretation that we adopted is the correct one,
yeah.
and that this was an early conference, could only have been called by a third of the branches, and it wasn't called, or at the request of a third of the branches, then surely the NEC can't do more than what the Constitution prescribes, and it cannot ratify that. It's not like an employee of a company who doesn't have authority and then you ratify it later. This is the Constitution. It's the ground law. They could consider Rule 17.2.1 with a view to possibly amending it. And let's leave aside questions of retrospectivity of an amendment, etc. But I have difficulty with this ratification argument, with respect.
My Lord, with respect, one cannot conflate the NEC with the National Conference.
Well, National Conference, the NEC is just the custodian between national conferences.
Yes, but we're not saying that the NEC would ratify anything.
Well, can the National Conference ratify something that was expressly, assuming the judgment to be correct, precluded by the Constitution?
They can ratify it, my Lord. If one reads Ramakatsa, and I haven't got the particular paragraph to hand, Ramakatsa says there was a decision made by someone to hold the provincial conference there. Now that is a decision, if the court's interpretation is correct, that was made without authority. The National Conference is the supreme body, according to the Constitution. It comprises all of the branch representatives, all of the delegates. And the Constitution gives those people in that forum, the National Conference, to ratify an unauthorized action. It's not the NEC that's doing it, it is the supreme body. And it goes back to the remarks that we made, or the submissions we made at the outset, that the composition of the ANC is essential. It's a body corporate which is run by voting. And the people who vote at a national conference can ratify whatever has been done on an unauthorized basis. And in this case, just as in Ramakatsa, if the court's interpretation is correct, there was an unauthorized decision that was made. It's not the National Conference acting contrary to the Constitution, because it's the Constitution itself that gives the National Conference that power to ratify.
I don't know that's correct to say unauthorized. It was unlawful. If the decision is correct.
Well, but one needs to antedate that finding. It was unlawful, my lord, because it was unauthorized. That's the effect of the court's finding. It was unlawful, not at the level of a criminal activity or anything that carries any criminal sanction. It wasn't unlawful because it breaks the law of the land. It was unlawful in the sense that we use that something was done without authority in a contractual setting. And it's quite apparent, my lord, in many cases that a lack of authority can be ratified by the supreme organ. If we're talking a body corporate, there's no difference between the action of an unauthorized official being ratified by the board of directors. The board of directors can do so.
Sorry, Mr. Howard. The powers to be exercised by the National Conference,
Yes,
those must be spelled out in the Constitution also.
they are.
Yes. So this power to ratify.
Yes, it's there. It's in
Where is it?
11.3.
Sorry, I don't know.
It's referred to in the judgment as well, my lord. Yes, if I can just read the wording. Clause Rule 11.3 says the National Conference shall have, and I'm going to delete non-material terms. The National Conference shall have the power to ratify any decision taken by any of the constituent structures, committees or officials of the ANC. And the express reference to it in the judgment of this court is in paragraph 159, where the following appears. As in Ramakatsa, this court should be disinclined to determine how the ANC should regulate its internal processes, given the powers in Rules 11.3 and 12.2.4 of the ANC Constitution providing for continuity. Consequences will follow from the declaration of invalidity, which going forward are best dealt with by the ANC itself in regulating its internal structures. And this finding, my lords and lady, comes, we venture to suggest, directly from the passages in paragraphs 121 to 125 in Ramakatsa, where the court there said in 125, quote, "We are disinclined to determine how the political party concerned should regulate its internal processes in the light of the declaration made by this court. We are satisfied that the ANC's constitution confers on the NEC or the National Conference adequate authority to regulate its affairs in the light of the decision of this court." And two paragraphs above it, it expressly refers to Rule 11.3. So what happened, to recap on the facts of this case, no voting irregularities are proved. A declaratory order is all that is sought ultimately on a trimmed back basis, because one will recollect that the applicants themselves initially in their notice of motion asked for an order specifically setting aside the provincial conference. And they retreated from that, and this court granted only the trimmed back relief set out in Ramakatsa. So we're left with a situation where we only have declaratory relief, and the court left it expressly up to the National Conference and to the NEC as regards how they should regulate it. And the court specifically referred to the powers of both of them to deal with the situation. Now we come to court on this application, and my learned friend's address today differs remarkably from their heads of argument. It seems to be a different tack that they've taken. There's no criticism. different counsel approach the matters from different perspectives. But the point that is made is that many of the grounds in their application and their heads seem to be pursued only on different grounds now, as were argued. We're told that the grounds of exceptionality are, firstly, that this is a declaratory order. Now, on our view of the situation with respect, the fact that it's a declaratory order does not justify the granting of an execution order. It's a factor that counts heavily against it, because it's not an order that is either ad factum prestandum, to do something, or in pecuniam solvendam, which is to pay something. And we've been unable to find any judgment, which is not to say that one does not exist, but neither side appear to have found any judgment in respect of which a mere declaratory order is put into effect. And if one looks at the section of the Superior Courts Act in relation to declaratory orders, it's quite clear that the court may grant a declaratory order even though there may be no consequential relief that follows from that. And that, we submit, is what happened here. And we've made the points in our heads of argument. So we have a situation where it's simply a declaratory order and there's no consequential relief. But the applicants now come to court and they try and persuade the court that there will be consequences. And with respect, they try and dictate both to the court and to the National Conference and the NEC what those consequences should be. In particular, the argument, as we now understand it, is that there are very strong prospects of success and that the appeal will fail. Well, with respect, we disagree with that, but we can come back to that. And secondly, they will suffer irreparable harm because these unlawful officials will remain in office as they are, and this is, moreover, irreparable harm. With respect, we disagree with all of that. It amounts to contemplating, firstly, prospects of success in their favour, and we disagree with the prospects of success. We say that this is two sides of the same coin. Whenever you argue the effect of an order being executed in the meantime, the court will approach the matter in an even-handed fashion. It will look at the one side of the coin, which is if the appeal should succeed, and it will also look at the other side of the coin, which is if the appeal should fail. The applicants look only at the side of the appeal should fail, but that prejudges the outcome of the appeal itself. And this court, with respect, is not sitting as an appeal court. If there is a finding that there is reasonable prospects of success, then it seems to be inconsistent with the finding that the appeal is hopeless. Because if the appeal is hopeless and will fail, then how can there be reasonable prospects of success? So we would submit that that argument holds no sway, the initial one.
Mr. Harper, this clearly is a declaratory order, but is it a declaratory order with no consequences? And I'll tell you why I asked that, because in your own head's paragraph 163, it is said the PEC, whether assessed as a whole or the remainder, are not working under any such apprehension. Then the important part, they realise that they have no right to remain in office if the order stands. So there's a consequence to this declaratory order. If it stands, they must vacate.
Yes.
So it's not an order that's just sort of in vacuo, or well, you didn't make that submission that Mr. Kuzwayo did, that said the whole Section 18 application is rendered a nullity because of the categorization of the relief that was granted.
My Lord, if I may answer?
Sure.
I understand the distinction, and with respect, we agree that there is a distinction. Our argument is not to say that there will not be consequences. Our argument is to say that there was no consequential relief granted, and the consequences were left to the NEC and to the National Conference. Our argument is slightly different. We say that being the case, that there was no consequential relief granted, doesn't mean there are no consequences. If the order stands, if the appeal, if we granted leave to appeal, and if the appeal is unsuccessful, then it will have consequences. But the court left the consequences, how they should take place and what they will be, to the NEC and the National Conference. And their application amounts to dictating through the order that they want as regards what should happen. And their whole argument is posited on the fact that they will succeed in the appeal court eventually, and there will be this irreparable harm in the meantime. We don't know that, my lord. We submit that our appeal should succeed eventually, and that if the present incumbents are taken out of office in the meantime, that they will suffer irreparable harm. But our point goes beyond that. We say the court never said that they have to be taken out of office in the meantime, because that would amount to a setting aside of their appointment, which was expressly pulled back from. And we say that to grant an order for execution on the basis they wanted would involve rewriting the order of this court to include some sort of consequential relief. And I think where Mr. Kuzwayo's argument comes in is, as I understand him, he says, absent that rewriting, then how are they better off than what they are now? Because it's just a declaratory relief. It has no consequential relief, and they can't dictate what the consequences will be. So how is the execution going to assist them at all? And the other side of that coin is, if they don't get execution, how will they be irreparably harmed? And there doesn't seem to us to be any sensible argument in that respect. Unless this court sits as the Court of Appeal and says, we will definitely find against our interpretation somehow that will happen. Well, if that's the case, then as I've indicated, we're not going to get leave to appeal. But if the court goes further and says we're stopping any execution in the meantime, then that's a different matter. But with respect, I see the Lord shaking the Lord's head.
No, we're certainly not sitting as a court of appeal.
Yes.
But we must take into account the prospects of success on appeal.
Yes.
So that is a bit of a sitting in judgment on your own judgment.
Yes. But and we agree with the notion. They argued something different in their heads of argument. They said prospects of success are not relevant. We said they are relevant, and we referred to these two Supreme Court of Appeal cases. So we agree that prospects of success are relevant. It's one of the factors that must be taken into account amongst all the other factors, one of the mix, as it were. But the mere fact that the court thinks that the prospects of success are good one way or another, we don't think gets over the hurdle of this is just a declaratory order, and the court has expressly said that it will not dictate to the National Conference or the NEC. And as we've indicated, there's no case made by the applicants as regards what those consequences will be, and they can't make that case because it's a matter within the discretion of the National Conference and the NEC. Now, one of the arguments they've made in their papers, and I haven't heard it persisted with today, but to the extent it may be considered relevant, I deal with it. They say, well, we are interested applicants and we need to save the NEC and the National Conference, and indeed the ANC, from itself, because if these people are not removed from offices, then there could be knock-on illegalities. Now, we take the point initially that this presumes that 4 individuals can dictate to the whole of the ANC what should be done. They presume to dictate what the National Conference may decide, where all the branch delegates are there, and they presume to decide what the NEC should decide under its express powers in the Constitution. So we're not surprised to hear that that argument's not persisted with, because it clearly would have no validity. So if I can just deal with the point seriatim raised by my learned friend. Firstly, exceptional circumstances. We say their argument amounts to this: because it's a declaratory order, that's an exceptional circumstance. Now, we disagree with that. Declaratory orders are granted on a regular basis in our courts. And the fact that there's no consequential relief granted with it is a factor against militating against execution, because there's no consequential relief to execute. There's nothing that anyone requires to be done. So they start off with a declaratory order and they end up with a declaratory order. Secondly, in relation to irreparable harm, the applicant's case is not that they would be elected. if there was another election. They don't say they would be in the interim structure that the NEC might decide to appoint. They say their prejudice is, well, they're going to be governed by an unlawful PEC in the meantime. But, my lords and my lady, if that is correct, that's what they signed up for in the first place, in the Constitution, because the Constitution specifically contemplates that the people who have the power to ratify are the National Conference, and the people who have the power to decide what should be done with a declaratory order of this nature is the NEC. So they can't complain if the NEC actually decides to do something in the meantime. And besides which, their argument is posited upon these officials being undemocratically elected. And we've made the submission that there were no voting irregularities proved and they were democratically elected. The calling of the conferences is something different. So we say there's no irreparable harm to them personally. If one looks at all of the cases that we've referred to in our heads of argument, they all deal, as we say, with orders that someone must do something, ad factum prostandam, and they all deal in the older cases with in pecuniam solvendam, that a payment must be made, in which case security must be put up. But in all of those cases, the common feature is what harm is suffered by the individual applicant. And there's no personal harm that's going to be suffered by these applicants. So we say they have no irreparable harm. And then in relation to the other side of the coin, the irreparable harm to be suffered by the present incumbents, well, if the relief was consequential and if they could somehow rewrite the Constitution so that these people must be displaced in the meantime, which they can't, then there would be irreparable harm to those persons, because if they are successful at the end of the day, then they will be finally deprived of their term of office. And equally, on the other side of the coin, they would be not entitled to exercise their democratic rights. They have been found to be perfectly validly elected in the appeal court in due course on that hypothesis, and they've been kept out of office in the meantime. So it goes back to the other side of the coin argument. Whatever argument they can make on one side of the coin can be made with equal force on the other side of the coin in relation to the exercise of democratic rights, with the crucial difference being the nature of this particular order. And finally, my lords, in relation to what was submitted today, one goes back inevitably to the test. And the Supreme Court of Appeal cases are quite clear that the previous position under the common law, that it was actually very difficult to get an application for leave to execute order granted, has now become strengthened. This is in the sense that it is now even more difficult than it was previously to obtain an execution order in the meantime. And that the default position is that the effects of the judgment, such as they are suspended in the meantime. Now, we've heard complaints, my lords and my lady, that this will take a very long time to get to the Constitutional Court, and we don't disagree with their timing. With respect, we do disagree with their timing. The time periods that they are referring to are at best for them the normal time periods. They do not take into account matters of urgency where a motivation can be made for urgency. And the fact that the Ramakatsa case got to the Constitutional Court so quickly is testimony to that fact. And we think that if they hadn't delayed the matter for 8 months initially, if they hadn't delayed 2 weeks in their application for execution, resulting in a postponement of the hearing of this matter, we would already be at least probably 10 months advanced, closer to a resolution in the Supreme Court of Appeal and possibly the Constitutional Court. So we say that it lies not very convincingly in their mouths to say, well, it's going to take a long time and therefore they're going to be deprived of the fruits of their victory. A, there is no victory. B, we submit it shouldn't take that long. if they want to move matters along urgently. And we will certainly not stand in the way of any motivation for an urgent appeal that there may be.
And the invitation to respond to the appeal and whether an appeal will be pursued,
My Lord,
and
I've
whether it
heard-
will be to the Constitutional Court directly or otherwise, or to the Supreme Court of Appeal.
Lord, I've heard the submission. The nature of the ANC is that it is very respectful of court decisions, and its default position is that it will get a judgment, it will study the judgment, and it will take legal opinion on that. And at this stage, none of that has happened. So the ANC will study the judgment and will take a decision based on that. That's all I can say. And that's been demonstrated by the manner in which they have dealt with the matter in the past. But having said that, I have no instructions to say to my Lord that we will not lodge an application for leave to appeal to the Supreme Court of Appeal. So I think that's all that my learned friend wanted at the end of the day. He wanted to say, well, do I have present instructions that we won't do it? And the answer is, I don't have present instructions that we will not do it. So it remains a possibility at this stage, depending on the court judgment and the ANC being allowed a proper time to obtain legal advice and to decide on the way forward. My Lord has... Sorry. Yes. Sorry, my instructions are to add there will be no purposeful delay following the court ruling. As I say, that doesn't detract from the possibility. Mr. Justice Kun asked a query that it's not clear what powers the PEC exercises. We have dealt with that in our supplementary affidavit. Incidentally, we've heard no objection to the admission of our supplementary affidavit, so before I conclude, I ask formally that our supplementary affidavit be admitted.
Okay, we didn't even deal with that aspect to clarify whether there was objection to it wasn't even raised.
No, it hasn't been raised, so perhaps this might be a convenient time.
The friend doesn't move for its admission.
Yes.
We do object, delivered at the last moment,
Yes.
and it forces us to choose between a postponement and not having an opportunity to respond. So
Well,
we do oppose the admission of that.
In any event, the issues raised in the replying affidavit, if they are new, this court will not take them into
Yeah,
account.
absolutely.
So likewise, any further affidavits will not be accepted at this
We
stage.
submit this.
But that application hasn't formally been brought before us, hence it hasn't been dealt with. But that clearly is the view of, I'm sure, our view on it.
Thank you,
Yes.
Lady.
Lady, my instructions are we never received a notice of opposition.
Yes, but you didn't move for the application either, Mr. Harper.
Well, my lady, the procedure
It
is
didn't
one-
automatically, then, it doesn't automatically mean it applies. That
No,
application
I'm
was
not
not
suggesting
drawn.
that they've consented to it. I'm just explaining that we served the application on them. And if an application is going to be opposed, you get a notice of opposition and possibly an answering affidavit in relation to that, or they ask for leave to deliver further affidavits. We've had none of that. So as far as we know today, the first time I hear that the application is opposed is when the learned friend stands up and says as much. Now,
Mr. Harper, just to cut to the chase on that, you wanted to refer to it in the context of my inquiry as to what the PEC does and what powers it has.
yes.
Is that not just then something new? You know, what I think my sister presiding wished to communicate to you was that if there's new material in the replying affidavit, draw our attention to it, and our prima facie view is to ignore it or disallow it. If the further affidavit deals with issues not previously canvassed in the affidavits, then I don't think it should be allowed to introduce those points. And thirdly, insofar as the further affidavit appears to note some objections by Mr. Zikalala as to statements and accusations that are made, really I put them on a par with the complaints about what Mr. was it Ntuli is alleged to have said about the court. You know, we're in a bit more of a robust environment, and those things are just by the by. I'm interested in the merits of the dispute.
Yes. Lord, we're quite happy to deal with it on that basis.
Yes.
The law, as we understand, as the court has a discretion. It can either allow new matter in and then allow a response to it, or it can disregard the new matter. So we leave that in the hands of the court. I do formally move for the application, but I anticipate that my lords and my lady will deal with that in the course of the judgment. So going back then to the point, it's the applicants who bear the onus of establishing irreparable harm, and it's them who would have to show that the powers of the PEC are going to be exercised in such a manner as to cause them irreparable harm. There's a dispute of fact on the papers whether one includes the supplementary affidavit or not, and there's been no reference to oral evidence, so they must proceed on the respondent's version. And on the respondent's version, the role of the PEC in relation to the National Conference is virtually non-existent. If the matter is going to be determined on a factual issue on that point, they have not demonstrated that the PEC remaining in place or being replaced by an interim structure of the same people, or whatever the NEC or the National Conference may do, will cause them irreparable harm. And it goes back to the point that we submit that they cannot dictate to the National Conference or the NEC what should actually happen, particularly in the light of the content of the order that was granted. I think, my Lord, I've dealt with the heads or the points as they've been submitted in oral argument. I don't know if my learned friend argued on the basis that all of the existing heads of argument remain in issue and have to be dealt with or not, in which case if they remain in issue, we refer to our heads of argument where we've dealt with all of those in a detailed fashion, and we maintain the submissions in that regard. If I may just look at my heads briefly and see whether there are any remaining points. Yes, in particular, this whole theory about there was definitely going to be a dissolution of the provincial executive in the meantime, and that a provincial task team would be put in place. There's a dispute of fact there. I think that the reference to the video conference was going to be relevant to that aspect, but I've heard no reliance on the video conference thus far. So the position remains is that the respondent's version prevails, and there was no decision taken by the NEC to dissolve the provincial executive in the meantime and to appoint a provincial task team. Even if there was such a decision, it would be the subject of a separate application to enforce that as a self-standing decision. And it's quite apparent from the papers that there were two meetings of the NEC, and the one was on the 22nd of September, as I recall, the other was on the 29th. Both of the resolutions are before the papers, and it's quite clear from that, read together with Mr. Mantashi's affidavit and Mr. Zikalala's affidavit, that the NEC did not decide to dissolve the Provincial Executive Council if they proceeded with the appeal, and they did not decide to proceed with the Provincial Task Team in the event of an appeal. Their decision is to appeal, to obtain the suspension, and then the matter is to come before the National Conference, which is to take place later this month, well, next month, before the end of next month.
Harper, if the PEC has virtually no role in the national conference, and the order of this court was not to be suspended, in other words, put into operation, what then is the harm to the respondents, other than, call it reputational, that they're no longer occupying those positions, and in the case of Mr. Zuma, receiving his salary?
Lord, there are a number of other functions that they perform in the meantime, and those are set out in the powers of the NEC. So there'll be a huge disruption.
Powers of the NEC?
Sorry, in the powers of the PEC.
Sorry,
there will
where's
be
that?
a huge disruption in the performance of their ordinary functions and role if they were somehow removed.
Just point us to where that is from the Constitution.
On the papers?
Just see if you can find the section in there.
Page 68. No, that's the Constitution.
It's 17.3.3.
That's of the Constitution.
Yes, of the Constitution.
Yeah, that's, they elect them.
The provincial secretary shall be a full-time functionary of the organisation. 17.3.4. That's in relation to the provincial conference. Will carry out and develop the policies and programs of the ANC in the province, have the right and power to review, etc., etc. And
That's the conference, that's not the PEC or the commission. Committee.
Sorry? Yeah, but where's it in the conference? Sorry, if the court will bear with me. There's another general section where it says between provincial conferences, the PEC was the highest power, which I'm just wanting to put my hands on. But the basic answer is this, is you've got a national level and a provincial level. And at the provincial level, it mirrors the functions of the National Executive Committee, but at the provincial level. So they've got to run everything between provincial conferences. So the entire administration rests in their hands. And we can see that it's quite a large body by that Rule 17 that I referred to. So all of the affairs of the province must be run by the provincial executive committee.
So how about in the section that you're looking at is on page 74?
If I can just get to that, my lord.
Well, I was actually more interested in the actual allegations, and that seems to be in the answering affidavit, page 154 onwards. The factual allegations.
Yes. I'm indebted to Mr. Justice Chetty that the powers are, there's a reference there to the powers. Yes, sorry, if I can refer to what has been referred to by Mr. Justice Kuhn.
Page 154.
Sorry, my lord, 150?
154, from paragraph 78 onwards, seems to deal with the irreparable harm suffered by the respondents.
Yes, it talks about them being, well, this is on the basis of the overstated relief that we don't agree with.
Yes.
But yes, that is the practical effect, but that's against the background of what is stated in the Constitution. Yes, sorry, the particular section I was referring to is Rule 19, Provincial Executive Committee. Rule 19.1, the PEC is the highest organ of the ANC in a province between provincial conferences and has the authority to lead the organisation in the province subject to the provisions of this Constitution. And then it talks about the composition, invited members, and then 19.9, powers and duties. It has to meet at least once every month. 19.9.2, it's got to carry out the policies and programs of the ANC in the province and do all things necessary to further the interest, aims and objectives of the organisation. It's got to carry out 19.9.3, carry out the decisions and instructions of the provincial conference, the PGC, the NEC and the NWC. 19.9.4, provide broad political and organisational perspectives to the Provincial Working Committee. It has to receive reports, supervise the work of and delegate such functions to the PwC as it considers necessary. It's got to manage and control the funds and assets of the ANC in the province. It has to submit reports to the NEC, etc., etc. It's got to issue and send directive and instructions and receive reports from the region's branches.
But it's all set out.
And so on. It's all set out there at great length. So if the appeal succeeds...
Yeah, but that's the theory, though. I'm looking at the specific complaints they have, and it seems to me, paragraph 83 in the answering affidavit, is just, they say, a deprivation of political rights.
Because those are the political rights. They would exercise it as members of the PEC.
Okay.
My Lord, I understand the Lord's submission, and if I understand it, it goes like this: well, what difference does it make if they're removed from their office? Now, again, with respect, that's not the submission of either side. The whole reason they want the execution order is because they say it will make a difference if they're removed from their office. The whole reason why we resist the execution order in its overstated position is that there will be substantial prejudice. It will have substantial consequences if they are removed. So it's not the version of either side that this is just something that, oh, well, if the declaratory order is put into effect and there's a removal of these officials in that way, that there will be no effect. So where's the harm? If I'm misunderstanding, my Lord, then I stand to be corrected. But I don't think, with respect, that's the situation of either side in this thing, that it doesn't matter. We say it does matter, and our antecedent point is the order doesn't say that this will be the consequence. But if it does, if it's on an overstated basis, putting it into effect in the manner in which they have will cause substantial irreparable harm to our clients. I'm not going to deal with Mr. Ntuli. We've dealt with the alleged strategy to delay the resolution of the matter. That's at page 193, paragraph 193 to 196 of our heads. There is no strategy on our part to delay the matter. We deal with the question of authority at 197 onwards. We've heard no argument on authority, and we submit that challenge died when they withdrew their Uniform Rule 7 notice. Sorry, is there something else? Okay. So, unless the court has any further questions.
Same question I put to Mr. Rengrove. If the application for leave to appeal is refused, is that the end of the Section 18 application on the facts as they appear in this case? Or do you wish to submit anything in that regard?
I don't think it is the end of it.
Well, it's tied up with the notion of, well, there are going to be further appeals. So even if the application for leave to appeal is refused,
I think in fairness,
the court should still entertain it.
Sorry, it's couched at the level of a possibility.
Yeah.
So it wouldn't, in our respect for submission, be of academic interest only. So that's according to our present instructions. Otherwise, my lords and my ladies, that represents our submissions. In relation to the question of costs, we submit that the application for leave to appeal should be dismissed with costs, including the costs of 2 counsel. And those submissions, of course, are on behalf of the 1st to 37th respondents.
The application for leave to execute.
Sorry,
Execute.
I beg your pardon.
I thought you were making a concession.
It wasn't a Freudian slip. That's a good people.
The 37th respondent fully agrees with the submission made by the 37th respondent for the sake of, so in order that we don't repeat the same argument, we will just simply agree with what they submitted in the court.
Mr. Chengro, do you wish to reply? We can just carry on. Do you think you need a lot more time?
No, my
So we could just carry on.
My learned friend, Mr. Nkantowi, will do our reply, and he's promised me it won't be longer than 5 minutes.
Okay.
My lords and my lady, my promise to Mr. Trongo was 10 minutes, not 5. So I suppose we can appoint the timekeeper. I've got only 4 points to make in reply. The first point relates to the question of the effect of the order. The court will recall that there is a contest about what the effect of the order is. Our learned friends rely on what we call a completely untenable construction to the order, because their interpretation ultimately boils down to this. Absent a decision by the NEC or the National Conference, the court order has no consequences. Now, it's untenable because the court order declared as unlawful and invalid and null, not just the decision to convene the conference, but the decisions taken at the conference itself. Those decisions include the election. So the fact of the matter is that as matters stand, according to the order granted by this court, the current PEC is null and void. It has no right to remain in office. And hence my clients are asking that they should vacate the office, because that is the natural consequence of the declaration that was granted by this order. To give it such a vacuous interpretation is simply inconsistent with the express language of the order itself. What our learned friends seem to fasten upon is the notion expressed in paragraph 158 of the judgment about what the other consequences might be. Of course, background context is important, and it's expressly referred to in the judgment itself, that one of the complaints raised in relation to the relief was the question of what would be the consequences in relation to appointed officials to government. And it was in that context that the court's response to it was that those matters should be left to the NEC. It would have been completely incongruous with the principle of the rule of law to render a judgment whose consequences are subject to the very party that was before the court. So not only is it clear in terms of the judgment itself that the election of the current PEC is null and void, it is also inconsistent with the principle of the rule of law to make a judgment that is subject to decisions by the NEC or decisions by the National Conference. So the effect of the order, as contended by our learned friends, we submit is completely untenable. The second point to make relates to this question about the powers of the National Conference. Our learned friends referred to clause 11.3 of the Constitution, which grants the general power to review, ratify, alter, rescind any decision taken by any constituent structures. But what our learned friends do not do, and we submit they simply cannot do, is to submit that the National Conference has the power to act in breach of the ANC Constitution. So 2 responses to the arguments ought to be made. The first is whatever powers the National Conference might be, including the power to ratify, it has no power to breach the Constitution of the ANC. The consequence of that is quite clear. The Constitution of the ANC is the founding instrument. Any conduct outside the parameters of the founding instrument is unlawful and unconstitutional. And there is no body, including the National Conference itself, that can act outside the parameters of the Constitution. What the National Conference might do is to amend the Constitution, if it wishes to do so. But as long as the Constitution remains, it remains binding. And there is something important for the principle of the rule of law in this idea that I am proposing. The Constitution confers rights on individual members. It is not open to the National Conference whenever it wishes to simply ride roughshod over those rights. Once those rights are created in the contract, which is the Constitution, they become binding in relation to the member and the political party. And for as long as the Constitution remains, the member and the political party are both bound by its terms, and the member is entitled to enjoy those rights qua member. And so when this submission is tied up with the first submission, it then becomes quite clear that there is no entitlement to hold a conference outside the parameters of 17.2.1, and therefore the declaration has a direct impact on the contractual rights of the members of the ANC. And because they are breached, the fact of the matter is that the entire decision that was taken subsequent to the breach is itself a nullity.
Sorry, Mr. If you look at clause 11.3,
Yes.
it says that the National Conference shall have the right and power to review, ratify, alter, or rescind any decision.
Yes.
What interpretation should be placed on those words, any decision?
Yes, it presupposes lawful decisions.
Yes.
But what it cannot do is to presuppose that you can now breach the Constitution and then run to the National Conference and say, please, National Conference, endorse my breach of the Constitution. So what I submit is that the National Conference is not comprised of external stakeholders. It is comprised of members. All of those members, as subscribers to the ANC Constitution, are bound by the parameters of the Constitution. And the role of the Constitution has been emphasized in various judgments, including the Supreme Court of Appeal. It is a founding document. It is a thing that brings them together in the context of a voluntary association. So there is no body that is entitled to act outside the parameters of its terms. So it is true that they may ratify decisions, but it presupposes lawful decisions. The second point to be made about this, which is completely destructive of the suggestion made by our learned friend, the second point to be made is that we must remember that the declaration of invalidity has been made by a court. It is simply incongruous with the rule of law to subject a judgment of this court to the wishes of the delegates at the National Conference. It is clear under Section 1C that the principle of the rule of law applies in South Africa. It is clear under Section 165 that the courts are superior, if not supreme. And they have declared what the law is. And it doesn't matter what the 4,000 delegates will do, because they simply have no power to alter the decision of the court. So if you adopted the construction around the ratification, what it will do is to subject a judicial decision to a political act by the delegates. That would be completely subversive to the principle of the rule of law. So that is why we submit that if you look at the first point we make, that they have no power to act unconstitutionally, you combine that with the second point that we make, that they have no power to undermine court processes. In fact, Section 165
bathi lokuza nami grand indaba okholo nani nani
Yabo.
phela ngizo ya ngicela ungishiye kanjalo ke yabo ukuze ngikwazi ukuyibona ngicela ungishiye kanjalo phela
Okay. Imaphela kulona.
okay bona mase ngiphuma shothi ngizobona ukuthi hayi ngiphuma
Yakiri. Bakhe bazoyilanda mangiqede. Awusheshe baba.
Ulala, ma.